Welcome to this month's Third Thursday webinar, brought to you by Synergy Settlement Services. The Third Thursday webinar is part of an ongoing free monthly webinar series. Each presentation is done by a Synergy subject matter expert who will tackle difficult issues that arise at settlement. During today's presentation, if you have questions, type them into the control panel where it says Questions. The following brief presentation will give you an overview of what Synergy does in 30 seconds.
Trial lawyer's job isn't to know all the nuances, to know what it takes to keep Medicaid in place or SSI and preserve Medicare and comply with the Medicare Secondary Payer Act and resolve these complicated liens that may be present. So all of those issues are issues that the trial lawyer really doesn't have the time or the expertise to deal with. They need a partner that they can rely upon that can handle all of those issues, and that's exactly what Synergy is.
Good afternoon. On behalf of Synergy Settlement Services and myself, I'd like to thank you for joining us on this month's edition of our Third Thursday webinar series. Today's installment is titled Hospital Liens versus Debts, a distinction with a big difference. We will be taking an in-depth look at what I call the lien-debt dichotomy and winning strategies to reduce hospital liens. My name is Michael Walrath, and I join you today on behalf of Synergy Settlement Services to discuss the hospital and direct provider liens that you so often have attached to your personal injury settlements. I have negotiated and litigated the reasonable value of health care essentially my entire career. I was formerly the National Director of Litigation for the Fairness Foundation, a nonprofit organization centered in Indianapolis, which represented uninsured patients overcharged by hospitals across the country. I also served as the in-house counsel to Olympus Managed Healthcare, and in that role directed the contracting and litigation nationally, often involving obtaining discounts from hospitals and other medical providers. From there, I founded a law firm in Miami, Florida, called the Medical Bill Clinic. And basically, we were a litigation firm that exclusively litigated hospital billing issues, almost exclusively in Florida, but some cases in New York as well. Those are the only two states that I am licensed in. And currently, I am the Director of Hospital and Provider Lien Resolution for Synergy Settlement Services, serving plaintiffs lawyers in every state of the country. And my line of business, of course, is limited to hospital liens and other direct provider liens, your typical letter of protection liens. So, before we begin with the substantive aspects of today's presentation, I'd like to do a short introduction on what exactly a hospital lien is. As many of you know and have experienced routinely, I'm sure, once you settle a personal injury case, you oftentimes have a number of lien holders to deal with who are seeking payment from that recovery. Most of those lien holders, I would say the majority, are for payors, for insurance companies, health insurance companies, who have paid for the accident-related care that your injured client received. Those plans, through contract and other mechanisms, including federal law in the case of ERISA, have reimbursement rights to be reimbursed the benefits that they paid out from the recovery that your client makes from the tortfeasor. Those plans include self-funded ERISA plans or insured ERISA plans. They include private health insurance and Medicare and Medicaid, FEBA. There are military liens. There's a number of different species of reimbursement liens that you've probably encountered at one time or another post-settlement. The liens that we're going to talk about here today, though, are quite different than those reimbursement liens. These are liens which I call direct provider liens in favor of healthcare providers who rendered care to your injured clients but have not yet been paid. and they are seeking to be paid for the first time from your settlement. Typically, that means the patient, the client, was uninsured, or the insurance company denied reimbursement, or in some cases, the hospital or medical provider refused to bill available insurance. Usually, that is in the case of Medicare or Medicaid. They've instead elected to proceed and pursue their lien rights against the settlement directly. So far, 40 states at this time and the District of Columbia all have hospital lien statutes which create lien rights against personal injury recoveries. I've listed those various state statutes here on the screen and highlighted a couple from states whom I know have a lot of participants here today. For example, Texas and California. Florida also has hospital liens, but they're not by state statute. They are valid by county ordinance in 9 of the 67 counties of Florida. That's been reduced. There were far more counties with hospital lien rights prior to some case law in the last few years, which invalidated a number of the county's lien laws and left only these 9 counties in Florida with valid liens. There are 7 states that have no hospital lien statutes at all, those being Mississippi, Ohio, Michigan, Pennsylvania, West Virginia, South Carolina, and Wyoming. And California hospitals, as I mentioned, do have hospital liens pursuant to the Hospital Lien Act, often referred to as the HLA or simply as 3045. Texas hospitals also have liens, a lien statute statewide under the Texas Property Code 55.001, and the Texas Supreme Court has somewhat recently weighed in and delineated some of the law surrounding those liens. Pennsylvania is one of the 7 states that has no hospital lien ordinance at all. However, Pennsylvania does have relatively good common law, case law, on the reasonableness of hospital debt. And we will, as you know from the title and perhaps from my blog, be getting into the difference between liens and debts here today. It's important to remember, though, even in those 7 states, for example, that have no hospital lien statutes, or in the almost 58 counties in Florida, which do not have hospital liens by ordinance, many hospitals create liens that are valid against your client's settlements by virtue of contract. They do this quite simply by adding language to their admission agreement, which gives them a lien right against future recoveries for the care that they rendered. So I'd like to give a few more examples of the wide range and scope of these laws and how much they differ from state to state. First, we'll start with a group of states that range from a statewide lien law to no liens at all. Starting with California, as I mentioned before, California hospitals do have a lien statute, Statute 3045, which limits liens to the lesser of reasonable charges or 50% of the proceeds. What that represents is a difference between a reasonable value argument and an equitable reduction argument. If a settlement is what I call fully funded, if a lien is a fully funded lien, in other words, the settlement is large enough that the lien can be paid without impinging on other liens or attorney's fees or costs or future damages, those types of things, then the lien would be reduced to the reasonable value of the care rendered. However, there's a limit, an equitable limit, which is written into the California statute that says only 50% of the proceeds can be applied to the lien. It is important to note that the California ordinance has been interpreted to place the burden of proof on the hospital to prove reasonableness. So that does increase your negotiating leverage, because essentially it is impossible for a hospital to prove up why the reasonable value of an aspirin is $50 when we all know that it isn't. Moving to Illinois, another state with a statewide hospital lien statute found in Chapter 770. That statute also has limitations. Similar to California, it limits charges to reasonable ones, but the equitable portion of the Illinois statute is limited to 40% of the proceeds. So no real rhyme or reason, just a smaller percentage in Illinois than California if you're dealing with a limited settlement. The Illinois statute also cuts off all lien rights on the date of settlement, which is interpreted to mean payment for the accident, recovery, actual tendering of funds. So once a case settles, no providers, regardless of whether it's accident-related care, have a lien under Chapter 770 in Illinois. That does not mean they cannot create a lien by contract. As many of you know, oftentimes uninsured patients are treated under letters of protection or similar doctor lien type documents. And of course, you can create these contractual liens post-settlement, and in fact always do. But these lien rights, the hospital lien rights granted by Chapter 770, are limited to care rendered before the settlement. And lastly, on this slide, we'll take a quick look at Ohio, one of only 7 states with no lien statute. There are also no county ordinances that I am aware of, so no statutory or ordinal liens in the state of Ohio. However, as usual, hospitals in Ohio can and often do create liens by contract with the patient, and all ethical and legal requirements and exposures would attach pursuant to a contractual lien, just like they would if there were statutory ones. Here we'll move to 3 more states, which range from a county by county patchwork to, again, a state with no liens at all, starting with Florida, which, as was mentioned, creates liens by county. Some county ordinances are valid, and a great deal of them have been deemed unconstitutional by the Supreme Court of Florida pursuant to the Shands v. Mercury case. As of my most recent count, 9 of the 67 counties in Florida still do have valid lien ordinances, and all of them are different. So in those 9 counties, it's very important to review the ordinances themselves, which are all available on MuniCode or whatever other service you might use to look up county ordinances, and to determine what the requirements, limitations, perfection requirements, all of those things can vary county by county in Florida. Important to also point out that all of the ordinances, with the exception of one county, with the exception of Hillsborough County, all of the ordinances limit liens to reasonable charges, but there is no equitable percentage delineated. What that means, not only is there nothing on the face of the lien law in all of these counties except Hillsborough, which limit liens to some percentage of a limited settlement, the case law has specifically interpreted these lien ordinances to be above any equitable considerations. There is no equitable relief available. Therefore, in Florida, if you were to file a motion for equitable distribution, for example, against a hospital lien, you would not prevail. 10 out of 10 times you will lose that motion. If by chance you were able to convince a trial judge to grant an equitable distribution and reduce a hospital lien accordingly, that trial judge would be overturned on appeal, again, 10 out of 10 times. That's unfortunate because it puts hospitals in a position to be able to not reduce if they choose not to, and take an entire settlement with nothing to attorney's fees or costs and nothing to the client. As we know, those of us practicing in Florida, that isn't usually the case. First of all, there are reductions to reasonable charges, as I mentioned, but also hospitals will negotiate and agree to accept an equitable percentage of a settlement because the business reality is they're getting free collection services from you and they don't want that to end. I'll move along to Texas. As I touched on before, liens are limited to reasonable charges, but they do not attach to work comp or uninsured motorist coverage. So it's important to take a look in Texas and make sure that you're only providing, you're only attaching a Texas hospital lien to the BI coverage. The UIM and the UM coverage is not reachable by those liens. Another nuance of the Texas law is that services must be rendered within 72 hours of the accident. So if care is rendered after 72 hours of the accident, it is not going to be able to avail itself. Those providers, those hospitals will not be able to avail themselves of the Texas lien statute. And somewhat recently, the Supreme Court of Texas has confirmed the reasonableness requirements in the Haygood case with some very good language that basically gives rather broad discovery of certain elements that the court has deemed relevant to the reasonable value of hospital care, which is important because of the reasonableness limitation in the Texas statute. Pennsylvania, another of these states with no statute or ordinances that I'm aware of. However, of course, it is important to check for contractual liens. I always recommend asking the hospital whether or not they have a lien, and if so, to provide documentation of that lien. And of course, it is the language of whatever contract has been entered into which governs all aspects of the lien in that case. There is good case law in Pennsylvania regarding the reasonable value of hospital debt. So should your client choose to resolve hospital debt from a settlement while they have an attorney and settlement proceeds to pay it, then there is good law there in Pennsylvania on reasonable value. And quickly, one last comparison of 3 states ranging from an all-payer state to a state with dueling statutes. Firstly, Maryland, the last all-payer state in the country, literally has a governmental commission that approves the reasonableness of hospital charges. Therefore, making a reasonable value argument is very challenging, in fact, probably impossible to litigate, although we do have some success on certain charges that seem beyond the pale. The statute in Maryland does limit liens to workers' comp rates, but workers' comp rates are limited to commission rates. Commission rates are the full bill charges, so that doesn't help you any. Moving on to Wisconsin, a state that does have a statewide statute limited to reasonable charges and does expressly protect attorneys' fees and costs, which is nice, and also limit the liens to charitable hospitals only. So it's important in Wisconsin to verify the charitable status of the hospital asserting the lien to make sure they can properly have a lien against your settlement. Liens in Wisconsin don't attach to work comp or wrongful death recoveries. That's pretty common. Most states, they do not. Virginia is an odd one in that it has 2 different statutes, one that applies only to private hospitals and the other that applies only to Commonwealth hospitals. Private hospital liens in Virginia, believe it or not, are limited to $2,500, period. Regardless of how big the bill is and regardless of how big the settlement is, the lien, the attachment to that settlement, is only $2,500, and then it is resolved. That does not resolve the debt balance. Very important. We're going to get into the difference between debts and liens in a lot more detail. So think back to Virginia when we do, and remember, if you resolve this lien for $2,500, you probably left a debt balance, and that debt balance is collectible, and the hospital will eventually come calling to your client for their money. The Commonwealth statute is different. It does not have that $2,500 limitation, and in fact, in the main body of the statute does not even include a limitation to reasonable charges. So it's more challenging to argue and made worse by the fact that the Attorney General's office is the last stop in that negotiation, and they do not agree with me that the liens are limited to reasonable values merely because they are the enforcement component of the statute does limit them to reasonable value. I think in litigation it's an open question. There's no law on it and you got a chance, but in negotiations, if the AG's office says no, then it's no. They do, however, negotiate fairly with regard to equitable reductions and splitting up a limited settlement. So the important takeaway from these last 3 slides is that the site of the hospital that treated your patient is very important. the law is completely different in the different states. Imagine a practitioner in Maryland whose client could very reasonably have treated under the District of Columbia statute, under the Maryland statute, where you can't even argue reasonable value, or under either of the two Virginia statutes, one of which limits the lien to $2,500 and the other which doesn't even consider reasonableness. So knowing the law that governs the liens attached to your settlement is quite important. If there is anything, any single thing that I would hope that you will all take away from today's presentation, it's this. There's a preliminary inquiry that you should make at the outset, post-settlement, before you start doing anything else to deal with hospital liens. And that question is this hospital pursuing a lien or merely pursuing a debt? I call this the lien-debt dichotomy. And I want to talk now for a little bit about what it is and why it is so important. But first, I want to explore perhaps some reasons why this issue is so commonly misunderstood or even ignored. The reason I chose this topic for both my blog and for this presentation is because I so frequently run into confusion over whether or not it even matters or whether or not a lien exists. And these things all, I think, flow from the fact that hospital liens and other direct provider liens are just so very different than the reimbursement liens that we find attached to the majority of our client settlements. Those reimbursement liens include your regular subrogation liens like ERISA, Medicare, Medicaid, those type of liens which are on behalf of health insurers or health insurance plans that have paid for accident-related care and now have a right of recovery, a right of reimbursement from your settlement. Those reimbursement liens are what I would call pure liens. There's simply no underlying debt associated with them. In other words, if you didn't make a recovery, you're not going to owe your health insurance company anything for the benefits that they paid for your injuries, or if you hurt yourself, you don't owe that money back. That's why you have insurance. It's what you pay premiums for. So effectively, almost all of these payors have availed themselves of lien rights by contract or by law, and therefore there's always a reimbursement lien for accident-related care when the health insurer has lien rights. It's automatically a lien by virtue of the care being rendered and being related to your accident. So it's just important to understand that medical providers who treat your clients are different. They always have an underlying debt, and only sometimes do they have liens. And as we'll see in a moment, all of your responsibilities and exposures turn on that distinction. So again, I have dubbed this difference the lien-debt dichotomy. And that title, the lien-debt dichotomy, basically stands for the critical difference between a lien and a debt, and the fact that that difference does indeed dictate not only best practices in resolving liens, but it also outlines your legal and ethical exposure. Remember, as we said before, liens can only be created by statute or by contract in this context. And by this I mean direct hospital liens or direct provider liens. They don't simply exist by virtue of an injury victim receiving accident-related medical care. They only can be created. This attachment to the settlement can only be created by statute or by contract. Otherwise, it is merely a debt, and that medical provider or that hospital is merely a creditor. I'm sure one of many creditors of your client. So before you begin engaging in any negotiations or even making a plan for which way to go with those negotiations, it is super important to determine whether the lien exists at all. And once you determine that it does, obviously it's important to figure out whether it's contractual or statutory and to review the terms of that statute or that contract. Once you have made that initial inquiry and you have determined that there is a valid lien against the settlement, you essentially have your marching orders. You then need to review the language of the statute or contract that confers the lien rights to begin with. You need to then, in my opinion, estimate the reasonable value of the care that was rendered and calculate the equitable reduction. In other words, whether it's in the statute, as it is in California, that it's limited to 50% of the settlement, or whether it's simply equitable distribution math where you gather all of the different liens and limit them to 1/3 of the settlement. However you do it, it's important to determine whether the reasonable value or the equitable reduction gives you a better result. And then you negotiate for the better or the lower of an equitable reduction or the reasonable value. And again, remember, most states that have lien statutes or even ordinances either completely eliminate or set out the equitable distribution formula. So it's important to follow the law in the state where the hospital is located that rendered the care. What if you make that initial inquiry and you determine that the hospital or the medical provider does not have a lien or does not have a valid lien? And by determine, I urge you to force that provider to agree with you, because there is a gray area in most states anyway as to whether or not, as to what happens when you and the provider do not agree whether they have a lien. In most states, if there is a disagreement as to the existence of a lien, you must have that adjudicated. You cannot be what is called, at least in Florida, the sole arbiter of that dispute. Instead, you must have that dispute adjudicated. So what I typically do is I obtain in writing a statement one way or another from the provider stating that they are not pursuing lien rights, that instead they merely have a debt and they are collecting on that debt. If that is the case, once you obtain that written statement, you are in the clear in knowing there is not a lien. So what do? Well, you get that in writing, as I said, and then you have to go to your client. You have to determine what your client wants to do because of the ethical requirements that if there are no liens attached to settlement proceeds, those proceeds belong to the client. And if the client demands that they be released, then they should be released. So you need to determine whether your client wants to resolve the debt from the settlement proceeds or not, because it is no longer a requirement that you do so since there's no lien. If the client does not want to resolve the debt, you can simply disperse upon demand, but I do recommend, strongly recommend, that you get a signed acknowledgement from your client that he or she understands there is an outstanding debt and that they have chosen, perhaps even against your advice, to take the money and deal with the debt themselves. If the client does want you to resolve the debt from the settlement proceeds, then of course you can negotiate for the reasonable value or an equitable reduction, just like if there was a lien. The distinction here is that it is up to the client. It's not mandatory. And when I say that it's not mandatory, what I am referring to is the ethics of the lien-debt dichotomy. If a third party has a lien, as many of you know, you are indeed ethically required to protect the alleged lien amount in trust until you amicably resolve it or have it adjudicated by the courts. However, if a third party is a mere creditor, asserting the assistance of a mere debt, you must, as I said in the previous slide, follow your client's directive as to whether or not to negotiate and pay that debt from the settlement proceeds. Because, again, there is always an underlying debt, but if there isn't a lien, that debt does not attach to these settlement proceeds. In summary, the ethical responsibilities and the exposure are exactly opposite regarding liens versus debts, which is exactly why this topic and the lien-debt dichotomy in general are so important to understand. The important difference between the lien versus a debt is its effect on any limitation to the amount. When a third party has a statutory lien and the statute or the ordinance, as the case may be, lays out the terms and the limitations, very often those laws limit liens to reasonable charges, as we discussed. And similarly, if the third party is merely a creditor, the common law often limits medical debt to reasonable value so long as the patient didn't agree to a price in advance. That's because the agreement to pay charges or the agreement to pay charge master rates or whatever the hospital admission contract says with regard to financial responsibility in most states is deemed to be an open price term contract into which only a reasonable price term can be imported by the courts. In other words, patients don't owe whatever the hospital says they owe after the fact. That would be too open-ended a right for the hospital to simply render service and then charge whatever they want. So that limitation to reasonable charges is quite different than the ethical responsibilities because it's the same whether there's a debt or a lien. Very often, and in most states, the amount owed to the provider is limited to the reasonable value or to reasonable charges. Now, equity is different. When a lien is subject to equitable reduction or equitable distribution, as the case may be, it's usually right in the statute itself. As we saw in California and several of the other states that we looked at, the statute itself, the hospital lien statute, states that the liens are limited to some percentage of a settlement. And as you know, the size of the bill is not limited to any of the settlement parameters. So liens are subject to equitable reduction if the law states they are, while debts never are. The amount that you owe a hospital as a patient is never a function of how big your recovery is. You would owe that same amount to the hospital even if you got no recovery. So debts are not subject to equitable distribution, while liens often are. Again, making that consideration completely opposite depending on whether you're dealing with a lien or a debt. And accordingly, reasonableness is the only commonality between debts and liens. It's the only common thread that you know permeates most liens and most debts in most states. And because reasonableness is the only common thread that runs through both liens and debts, I wanted to talk a little bit about reasonable charges, what they are not, and how best to estimate them. But before doing so, I always ask folks to think a little bit about what they're doing now. What is your methodology, your process to resolve hospital and other direct provider liens? When I ask that question of folks in our live sessions, which one day I'm sure we'll get back to, I typically learn, and not surprisingly, that most firms and attorneys basically engage in blind negotiation from the full bill charge. Face it, most attorneys don't have anything else to work with. The only document you have at best is the itemized bill and the hospital's full bill charges for the care that they say they rendered. Unfortunately, most folks, and I try real hard to avoid this, and my team is constantly working on our language and our methodology to avoid even framing things in this manner, but usually this negotiation is framed by both parties as a discount from the full bill charge. In other words, sort of assuming or conceding, as the case may be, that the full bill charge is actually owed in the first place, and in reality it is not. So I don't feel that framing this as a discount is appropriate. In fact, I go so far as to tell hospitals when I'm negotiating these liens that I'm not looking for any discount at all. I am ready, willing, and able to pay 100% of the amount owed to the hospital. The only disagreement we have is how much is owed to the hospital legally. because the law is clear that only a reasonable amount is due and owing. What I also learned from most folks that I talk to about their sort of status quo on hospital lien resolution at their firm is that they're often willing to accept, again, to use the wrong terminology, the best discount they can get. In other words, once they reach impasse, they advise their clients to accept that best discount. And I often hear that 20 to 30% is a rather common amount to see as an ending point. This, of course, begs the question, what is your firm's average reduction? And in those live presentations that I hope to get back to soon, I always start by asking the group what sort of reductions they're getting. I typically hear that the firm will not accept less than 20% off, that 30% off is probably the average, it wouldn't be considered bad or great, and that if you can get a hospital to reduce 40% from its full bill charges, that's a home run. And if that sounds familiar to you and your experiences with these types of liens, then you're in the majority, and there's certainly nothing wrong with that. However, I do think that there's a better approach, and thankfully, it's a pretty simple one. What you want to do is you want to negotiate up from the reasonable value instead of negotiating down from full bill charges. I call this inverting the argument, and it really requires just a few steps, and it makes a dramatic difference in the result. First, you do have to define the reasonable value, which I define as the cost of care plus a reasonable profit. Then you have to calculate or determine that reasonable value, and you negotiate from there. The cost of care is a very important data point, and luckily, with hospitals at least, it can be derived from a facility's hospital cost report, which is submitted to Medicare annually under oath. This form, several hundred pages long, includes every single cost incurred by the hospital and designates them to the various revenue centers or departments in the hospital, all the way down to the CT scan department's pro rata share of parking lot maintenance. It really is a remarkably detailed report. Now, experts routinely testify in both litigation and before Congress that hospital profits of 40% to 50% above costs are reasonable, that a hospital can thrive, not only survive, but thrive on a 40 to 50% profit margin above its total costs. Many times people ask me, well, that's all well and good, but we are talking in the abstract a bit. What can I expect the reasonable value to be in terms of full bill charges? And that, while it's an average and it's not perfect, there's an answer. And what I see on average as the reasonable value of a hospital bill is that the reasonable value is approximately 20 to 35% of the bill charges. But of course, it can be more or it could be less, because it really depends on what care is rendered and what costs that particular department where that charge emanated from were incurred. At this point in the presentation, last time I gave it, I received dozens of emails. The lines lit up, so to speak, with people asking, well, how do I get this cost report? Where do I find this data? This is too good to be true. I assure you it's not too good to be true. The data is definitely out there, and there are several ways to get it at several sources to get it from. Hospital cost report data is available online directly from CMS. However, my understanding, and I've looked at it several times, but not in great detail, is that is the raw data. And the raw data, if you are not a data analyst, can appear a little bit dense and difficult to use. It's not in any sort of user-friendly format. It's just the raw data that CMS has collected from these hospital cost reports. You can get actual reports, the document that each hospital submits to the federal government every year can be obtained from CMS or from government hospitals through a FOIA request, and it may be available online as well. I'm not certain about that, but CMS has it, and we do have a right to see it. There are also some subscription services available that provide access to different views of that hospital cost report data, and some of those views are certainly more user-friendly than the raw data and even than the actual cost report that was submitted. And lastly, of course, if you are litigating a hospital lien, you can certainly request the hospital cost report from the hospital in discovery, and you could even depose the folks who prepared those reports, and I recommend you do so if you're litigating, because it is quite instructive having the person who prepared the report explain to you exactly what everything means. Last but not least, of course, Synergy accesses this data and has also built a paradigm that uses this data to arrive at various calculations based on individual bills. So when we are hired, we not only access that hospital's data for the year the care was rendered, but we also do all of the calculations necessary to estimate the reasonable value of the care, and then we use that estimated reasonable value to negotiate the hospital lien that we've been hired to resolve. Cannot overestimate the importance of inverting the argument. The results obtained are dramatically different, dramatically better, as you would expect, than the results that you get when you start at a patently unreasonable, unilaterally determined, inflated full bill charge that nobody pays. That is just unquestionably the wrong place to start. And I wanted to go through a case study to show you exactly how those results compare so that you can see for yourself. This case was a case that we were hired to handle after the attorney took their first shot, got the best reduction they could get, and then wanted to see if we could do better. The full bill charges were about $95,000, and if you use the traditional blind negotiations that we talked about before, in other words, if you simply negotiated down from $95,000 to see how good of a quote-unquote discount you could get, the results would be as follows. If you were able to get the hospital to give you a 20% discount, as we talked about before, that would be the minimum for most firms. They say they wouldn't resolve it for less than a 20% discount. You'd pay $76,000 and you'd be giving the hospital a 641% profit. If you were able to get 30% off, that, as you'll recall, was the average, not good and not bad. You would be paying about $67,000 and still giving the hospital approximately 420% profit. And lastly, at that 40% discount, which you'll remember was a home run from most of the firms that I talked to, you're paying $57,000 and still a 344% profit to the hospital. But now let's look at the same case with the argument inverted. Full bill charge of the $95,000. Remember, the first step, determine the reasonable value. And we did so, and we estimated that reasonable value based on the hospital's cost of care plus a 50% profit margin was about $20,000. We then argued up from that reasonable value of $20,000. And if you do so, these are the results at various points. So if you were able to get the hospital to accept 25% above the reasonable value, you would pay $25,000 and you would obtain a 74% discount from the full bill charge. If you couldn't get it done there, but you could get the hospital to take 50% above the reasonable value, you would then be at about $30,000 and an almost 70% discount from full bill charge. And even if you paid the hospital 100% above the reasonable value, you offered them 2 times what you believe the legal limit is. You would pay them 40 grand on this bill and you would obtain an almost 60% discount from the full bill charges. So when we were hired to resolve this hospital lien, we did exactly that. Remember, full bill charges of $95,000. And in this case, the hospital had offered the injury attorney a 30% discount before we were even engaged. In other words, they had already agreed to accept approximately $67,000. So when we took the case, our job was to see if we could do better. And we started at the reasonable value and we negotiated up and we ultimately settled for 50% above the reasonable value, which was $30,000. Now, Synergy's fees are based on a percentage of the additional savings we obtained. Remember, we do not charge for the 30% discount that the injury attorney obtained before we got involved. We charge only 15% of the savings below that amount. And at that rate, the Synergy fee was calculated off of the $36,819 in additional savings, which resulted in an additional net savings to the client after paying the hospital and our fees of $31,000. This does mean that if the client had accepted the 30% that the injury attorney was able to secure before engaging us, they would have paid the hospital $66,800, but instead by hiring us, they paid only approximately half of that. They put an additional $31,000 in their pocket from their settlement proceeds merely because they chose to hire Synergy to carry the ball a little further down the field. Therefore, there are some pretty compelling reasons to consider using Synergy to assist by negotiating the hospital liens that you face after settlement. Principal among them is that we already have all of the ammunition that we need to do everything that I described here today. We are assigned to resolve a hospital lien. Our first step is having our billing and coding experts identify and remove any billing errors or non-billable charges that they find. And then we calculate the hospital's cost of care on all of the remaining billable charges. We add a 50% profit above that cost and apply this estimated reasonable value to the law in the state where the hospital is located so that we can pretty easily determine the best route, whether or not we should be proceeding on a reasonable value track or convincing the hospital to accept an equitable portion of a limited settlement. Once we use the hospital's cost data against them in this way, we can identify and talk about the amount of unreasonable profit this hospital is trying to exact from our injured client. And in doing so, Synergy really levels the playing field. We no longer have to rely on the hospital's full bill charges as the illusory starting point, and instead we rely on the actual data that's relevant, and we negotiate up from a reasonable value, resulting in dramatically deeper discounts than the traditional hospital lien negotiations. So, in conclusion, using our hospital lien resolution services always results in a net pre-suit savings, or there is no fee. Our fees are usually passed along to clients as agreed costs on the closing statement, so obviously the attorneys don't pay anything for this service, and the results either benefit your client or they are risk-free. There's no cost associated with them. So I hope that you'll consider whether or not Synergy might be a value add to your next hospital lien negotiation. And if you're not sure and you just want to ask some questions or even talk through a negotiation that you're handling, I'm happy to do that. So please feel free to call me or email me anytime with any questions that you might have. I'm happy to discuss actual issues you're handling or discuss whether Synergy can help you out and what that would look like. This is my contact information, and I hope you'll take note of it. I'm happy to speak to you. Thank you very much for all of your time today. I hope that this was helpful to you and you got something out of it. As I said at some point during the presentation, if I could have anything, if I could have one strong takeaway from this kind of long presentation, it would be that you now appreciate how important the difference between liens and debts and some strategies for reducing that work perhaps better than the ones you're using now. Happy to be a resource. So I look forward to hearing from you. Thank you so much. Bye-bye. And speaking of questions, I wanted to address a few of the questions that we received. I don't think I'll have time for all of them, but I do have a few minutes left here and wanted to cover those that I received. First, I received several questions, all different versions of the same thing as I read them, regarding equitable distribution and all of the stuff that I said about reducing to an equitable amount. In other words, you have a limited settlement. You're not looking at the reasonable value of the care. You're instead asking the question, what would be a fair percentage of this limited settlement to pay to the hospital? And the questions that I got on equitable distribution were all related to something that I think I must not have explained very well, because it is something that you have an opportunity to argue even if it leaves a debt balance. So you could argue for an equitable reduction and leave that debt balance, or you could, and frankly, we always do, ask the hospital to accept that equitable portion as payment in full. And many hospitals do so. And the reason is simple. It is because the patients who are uninsured, which are usually the folks who have hospital liens attached to their settlements, or else it would be a reimbursement lien, right? Those folks are quite often judgment proof, and nobody knows that better than the hospitals. So a hospital can reasonably look at this offer of an equitable share of a settlement as all they'll ever get anyway. So you can quite frequently ask the hospital to accept the equitable portion of the settlement, of the limited settlement, as payment in full. And if they agree, then there is no debt balance, even though there was. The other reason that it works quite often is because hospitals have charity care programs. While they will not put your client through a charity care program while there's a settlement and you're negotiating your bill, once they agree to accept an equitable portion of that recovery, the debt balance, the patient is now a purely self-pay patient, and you could, in many instances, apply for and be granted charity care. So I didn't mean to suggest that every time you negotiate for an equitable reduction, you leave a debt balance. That is the technical result. An equitable distribution does not affect the balance as a matter of law in every state that I've researched that, certainly in Florida and New York, but hospitals will often accept it as payment in full. So hopefully that answers most of the questions about equitable distribution. If anybody has any more, please feel free to give me a shout anytime at those contact points that I had on the screen a moment ago. Two other questions that we received, both from attorneys in California, and both issues that are somewhat, well, one that's particularly unique or prevalent, as I should say, in California, and that is balance billing. In most states, almost every other state really, when a patient has health insurance and the health insurance pays, and you have those original liens that I was speaking about here today, those reimbursement liens, you're not going to have a hospital lien for the balance. And there's case law in a whole lot of states, including Florida, on this point. And the reason is simple, because there's no underlying debt anymore. It's the same thing that we're talking about. When a health insurer has a contract rate, pays that amount to the hospital, that contractual write-off is gone. You don't have a debt for that, therefore you don't have a lien for that. California is different, unfortunately, in that regard. It's one of the very few states, the only one that comes to mind off the top of my head anyway, that the courts have interpreted that issue a bit differently. They've sort of agreed with what I just said, but then there was a case called Parnell, and the Parnell case basically said, well, here, I'll read you the quote. The Parnell case said, if hospitals wish to preserve their right to recover the difference between usual and customary charges and the negotiated rate through a lien under the Hospital Lien Act, they are free to contract for that right. That's quite an invitation, and a heck of a lot of hospital systems have accepted that invitation, have changed their contracts, their contract between the hospital system and the health insurer, to include a lien right for the contractual write-off. I find that horrific. I really, it's a terrible, terrible thing if you ask me, but that is the law under the Parnell case in California. Remember though, that only applies to private health and only if the provider agreement between the hospital and insurer says so. So definitely in private insurance situations in California where the hospital is attempting to balance bill, you should get a copy of that provider agreement. And in my opinion, although I've not seen any law on this, get something that shows that the patient agreed to that provision, because it would be a change. This provision didn't exist in any of these plans until the court invited it to. So they're all, somewhat new. The Parnell case, I don't have the date in front of me, but it would be since the Parnell case that the plans amended to give themselves this lien right. So they would have, in my view anyway, had to have the existing members agree to that lien right. So that's how I'd handle that. And this balance billing problem in California does not apply to Medicare and Medicaid. So they're not able to balance bill the contractual write-off or the non, the Medicaid and Medicare rates are all the hospital's getting. There's no underlying debt, and Title 42 of US Code 1395 effectively prohibits balance billing. So you shouldn't see it in Medicare, Medicaid, and if you see it in private health, it's a creature of contract. The other question I got from California was that there's apparently some hospitals arguing that they can assert their lien under 3045 against the UM/UIM coverage. In other words, against first party coverage. I took a quick look because this question came in during the presentation, so I was able to look and see if I had any case law that interpreted 35 on this point, and I didn't see any. I'm going to do a better search. It was a little cumbersome to do in the midst of the presentation, but I didn't see any cases that interpret it. However, 3045 specifically says, and this is a quote, hospital shall, if the person has a claim against another for damages on account of his or her injuries, have a lien upon the damages recovered. So this language against another has been interpreted in a number of states. And every time that I'm aware of, it has been interpreted to mean third-party coverage and to exclude first-party coverage, because first-party coverage is not a claim against another. So I've not seen that yet in the California case law. I'm going to do a better search, and whoever submitted that question, if you want to shoot me an email directly to remind me to send you the answer, that's great. Otherwise, I hope you're able to beat that back, because they should not be asserting liens against UM. So I want to thank you all very much. It's been a great opportunity to talk to you, and we hope to hear from you. Good luck with these direct provider liens.